Think law is all dusty textbooks and boring rules. Let me introduce you to a cricket ball, a runaway cow, and one of the strangest ways to learn negligence. Here's a short extract from one of our CILEX CPQ tuition videos.
So there are a number of factors which need to be considered by the court when evaluating whether a defendant has acted in the standard of the reasonable person. The first thing they're going to look at is the magnitude of risk. What this means is how likely or how significant the risk was. And this was considered in the case of Bolton and Stone. In this case, we had a woman in Manchester who was walking along the street when she was hit by a cricket ball. This cricket ball had actually cleared a 17-foot fence, and it had made its way out of the cricket club onto the pavement and had hit Miss Stone as she was walking along. She suffered injury and she wanted to sue the club for negligence. So, in order to show a breach of duty, Miss Stone needed to prove that a reasonable cricket club would have done more to prevent the accident. And in making their decision, the House of Lords focused on three different things. These things were the likelihood of the harm taking place, which is another word for the magnitude of the risk. So, in roughly 30 years, a cricket ball had only left the grounds a handful of times, and it had never previously injured anyone. Because the chance of injury was so remote, the risk was classed as very small. In other words, a very low magnitude. Then there was the practicality of further precautions. The club already had a very tall fence, 17 feet. Building an even higher barrier would have been expensive, it would have been unsightly, and it would have been unlikely that it would have provided really any extra benefit. And finally, it looked at the social utility. So cricket provided a lawful and valued recreation for the community. And the law is really quite slow to try and prevent socially useful activities unless the risk is significant. So the risk was really small here, and therefore the decision was that no breach had occurred. A reasonable club, knowing the history of rare hits, would not have gone to greater lengths, and the tiny probability of harm did not justify any extra cost or inconvenience. So what do we learn from this case? Well, to put it really simply, the court will consider the likelihood of the risk, also known as the magnitude of the risk, when deciding whether or not a defendant has behaved as a reasonable person would. And the less likely or the more remote the risk is, the less the defendant needs to do to guard against the risk, and still to be seen to be behaving reasonably. This can be thought of in terms of foreseeability. The more foreseeable an event is, the more likely it is that the defendant will have a duty to guard against it. Another example of this application of this principle might be one of the best cases I personally have ever read and that you might ever read. And this was the case of the cow that was on the loose. Welcome to the case of Cameron against Hamilton's auction marts in 1955. So I'm going to need you to picture the scene, and I promise you this did actually happen. So, there is a nervous cow being unloaded from a lorry onto a bustling Scottish auction mart. Uncertain about her future, the cow makes a break for it. First, the cow smashes through a gate, then trotted onto the street, and finally managed somehow to climb up an external stairway above a nearby shop. Yes, really. Then, once in the shop, the cow's weight is too much for the upper floor. It was never really designed to bear the weight of a cow, so the floorboards gave way, and the cow crashed into the shop below. Predictably, the cow is quite startled by all of this and somehow manages to not only knock over lots of different key items from the shop and sort of damage lots of things, but also turn on a tap. And the tap floods the premises and ruins the shopkeeper's stock. The shopkeeper then decided to sue both the auctioneers and the farmer in negligence. The central question being the same one posed in cases like Bolton and Stone. Was the harm reasonably foreseeable, and what was the magnitude of the risk? And of course, the answer was the risk was vanishingly small. And because the mishap was so extraordinary, neither the auctioneers nor the farmer had breached any kind of duty of care. Reasonable stock handlers secure gates. They do not expect livestock on the loose. So there was no breach of duty here. So that's Cameron and Hamilton's auction marts. So again, they were looking at that magnitude of risk and working out how big it was. And of course, it was absolutely tiny. No one would have expected this to happen. And even reading the case, you might doubt it happened at all.
That was just a small sample of the CILEX CPQ Foundation tuition our students get access to. Across F1 to F6, we have over 58 hours of video content designed to make legal principles clear, memorable and easy to apply. Visit the Astranti website to find out more about our foundation course or sign up for our free F1 to F4 mock exams if you're already studying.